My name is Anthony Stonecipher. I'm a 100% disabled veteran. I've had 6 brain surgeries and both frontal lobes removed. What you're hearing now is how I speak when I'm not aphasic. On March 28, 2025, Judge Ochoa in the New Mexico court knowingly held a hearing while I was aphasic, unable to speak, and denied 88 accommodations, including my prosthetic memory device, which he had personally approved in a signed order. What follows now are real audio clips from that hearing. No filters, no edits, just the truth.
In the matter of City of Alamogordo versus Anthony Stonecipher, Cherokee cause LR 2024-9. Parties, please announce your appearance for the record.
On behalf of the City of Alamogordo,
Jonathan Miller for the defendant is appearing by video with prior permission of the court.
Good morning. We are here to address the remaining motion to dismiss filed on November 22nd, 2024. It was a pro se motion at the time. Mr. Miller has since adopted that motion via pleading, and I believe he plans to orally assert so this morning. Is that correct, Mr. Miller?
That is correct, Your Honor.
All right, Mr. Stonecipher, please raise your right hand for me and unmute yourself. There you go. I saw you muted, but your screen is frozen. Can you hear me, Mr. Stonecipher?
Yes.
Okay. I do. So let me put you under oath. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth under penalty of law?
Yes.
All right, Mr. Miller.
Mr. Stonecipher, what is your disability?
Brain damage.
And what was that caused by, sir?
Mortar.
Are you an honorably discharged veteran?
Yes.
And do you currently have a caregiver?
Yes.
All right. And when you were charged with this case, and I don't really want to go into the details of the case itself, when you went to trial, what accommodations did you ask for?
Confused. Morning. Not good.
All right, then I guess, Your Honor, since he has noted that he's having some confusion, I will stand on the motion, Your Honor. I believe
Made a number of 88 orders in compliance with the defendant's objections or requests, and the fact that the defendant is getting a de novo appeal in which the court has granted his 88 compliance requests. There is a potential argument for prosecutorial misconduct within this motion, and the court is going to deny the motion to dismiss due to the municipal court's actions regarding ADA compliance. And I do not believe that there's been sufficient evidence to show that the municipal court judge intended to cause a mistrial, or that the municipal judge intended to cause a retrial or reversal. I also don't think that any action by the city prosecutor rises to that level either. If the court does not find one fact, the court need not address the remaining factors. I'm not going to address the remaining factors.
normally I would call my client, but I don't believe he's capable of responding to questions. But if I may have a breakout room with him, Your Honor.
And Mr. Miller, because I am, familiar with this, because this happened in municipal court, I will just let you know that when this happened in municipal court, we had to recess and for the whole day. Just food for thought, I guess. But I just wanted to let you know that when I've experienced him like this, usually we cannot proceed for at least an entire day.
Your Honor, I do want to make a record. My client did email me. He has informed me that his brain is not working right, and he feels that he is not getting sufficient accommodation. He can't help in his defense. The other thing, I did want to put that on the record. I did also want to state he wishes for me to cite State versus McClaugherty, 2008 NMSC 044 or 144 NM 483. he believes that the prosecutorial misconduct causes prejudice so severe that retrial should be barred under the double jeopardy clause, even if that was not intentional. Again, that's State versus McClaugherty, McClaugherty, 2008. And
previously, the defendant had raised the issue of not being able to cognitively intake the information, and the remedy was to make available the hearings after recordings of the hearings after the conclusion of the hearings. And so,
what is he's putting up his phone? I'm not sure what.
Unfortunately, your client's showing me that he's violating the court's order, that he's not supposed to record conversations between his attorney and himself. But we'll address that on a different day, I suppose, because I don't know what to do. So,
Clearly stated in the order, Mr. Stonecipher shall be allowed to record the conversations between himself, his caregiver, his counsel, and members of his defense team while he is at counsel table. He may use his personal recording device for these recordings. Additionally, the district court will provide the recording of each day. The court's proceedings shall be made available to Mr. Stonecipher as soon as possible after court's proceedings.